Good morning, everybody. Thank you for coming to this, the second in our series of talks, Litigation Lessons, Preventing Professional Negligence, with myself, Graham Mead, and my colleague, Ellie Claffey.
Hi.
Good morning. You'll appreciate this is our second session, and the feedback that we received from the last session was that professional negligence was an area of interest. Looking at the delegates that are here today, there's a wide spread of professionals, and so we have an hour to run through everything and to try and sort of give a briefing. So forgive us if this isn't necessarily targeted at your particular area, but we're going to try our best to sort of give you a flavour and to give some tips and takeaways. So today I'll be running through we'll be running through the basics of professional negligence, touching on a few different elements, touching on common pitfalls and how to avoid those based on our experience, how to proceed if a claim presents itself, and then we'll touch a little bit at the end on some recent case law.
Thanks, Graham. So an overview now of professional negligence. Professional negligence in short, is what it says on the screen. It's a situation where a professional fails to exercise a standard of care expected of them in their field, resulting in financial loss and other harm to their client. Now, the main point being that professional service was acquired in one way or another, and that service did not meet the standard required of that professional, and it resulted in some form of a loss. There are a number of weird and wonderful ways professional negligence can transpire, and so it's probably going to be helpful if we consider some examples. So when we talk about professionals, we're talking about people such as builders, surveyors, accountants, personal trainers, and solicitors. People who are qualified in their specific field and have an advanced or some form of specialist skill. Now, examples of professional negligence, they may include a solicitor missing a court deadline, an accountant giving improper tax advice, an architect designing a flawed plan, a surveyor giving an inaccurate property valuation, or even something like a personal trainer failing to identify a risk. Now, these are just some examples of professionals and situations which may give rise to professional negligence claims. It is by no means an exhaustive list.
Thank you. So another point I just wanted to touch on really was the difference between contract and tort. And apologies, because I appreciate, again, going back to who is watching this, some of you may have had training around legal aspects, and so this may seem sort of a fundamental, but just to explain, we all really know what a contract is. As professionals, you'll send out engagement letters, you'll send out your terms of business, and those terms effectively govern the relationship that you have in contract. But just to explain, there is also the law of tort, which effectively fills in where there are scenarios where perhaps there isn't a contract, but where a duty is owed, and the court over the years has defined where these kick in, and one of them is in regard to professional negligence. And again, a simple example of this from everyday life would be when you get in the car and you drive. You've not signed a contract with every other road user on the road, but the law implies a duty on you that you will drive your car with due care and skill. And so if you have an accident, when you're sued to as it were, recover the damage of the car or to recover on a personal injury, that is effectively dealt with under the law of tort. In professional negligence, to recap again, you usually owe two duties. One is the contract, as it were, and the other is this ongoing sort of professional duty. So again, even if you don't have a contract in place, I appreciate one is likely to be implied anyway, but you do have this wider duty as a professional. And again, just looking at the slides, Donahue versus Stevenson, 1932, is really the starting point of tort, if any of you want to delve into that. I've touched on its concurrent duties. Sometimes, again, contractual duties can be more onerous. A tort really will just keep you and hold you to a professional level, where obviously if you're designing an oil rig or something, you're likely to have a contract that implies far more. So again, tort's not really something to be afraid of. other than, any more than contract, but it is still it is still there. Contracts can also, and again we'll come on to the importance of a robust contract, they can also try to exclude or limit any tortious liability and availability of remedies that you might have. But the main reason really I raise this is the measure of damages. So I'll keep it simple, but really under contract, the measure of damages, or what is recoverable, is really the damages for a scenario where you would have got to had the contract operated properly. So, if the bolts have been delivered on time, the engines of the bolts were going to go into have been manufactured and then been picked up and purchased by, say Rolls-Royce or whatever, you would then have a profit and you would have, as it were, a more abundant future because the contract had been concluded properly. And so your measure of damages in contract is to put you in the position, I'm being very broad brushing, but to put you in the position you would be in had the contract been properly fulfilled. And there's a little bit more, as I say, abundant tort damages are really to put you in the position you would have been in but for the breach. And so really they can still be significant, but it's almost a position to returning you to your original position rather than necessarily compensating you for a better position. And a good example of that, without being too macabre, would be, say, a personal injury claim. If you have an accident, you have whiplash, or you lose a limb, the damages that you would have for that tortious claim would effectively be to enable you to function as if you didn't have whiplash and as if you didn't have, as it were, a missing limb. So it's a subtle difference, but it is important when we're looking at claims to really see, as it were, whether what is being claimed is viable and is allowable in law. But anyway, that's contract and tort. Over to Ellie.
Great. So the building blocks of professional negligence. Negligence really does boil down to sort of three parts. And I'm going to rattle through this. So if you have got any questions, then do just put them in the chat box and we'll deal with it all at the end. But first we have the duty of care. Now, as Graham has touched on, a duty of care can arise in several ways. On the slide, I think I've put down statutory, fiduciary, contract and professional code of conduct. So you have statutory duties which are imposed by legislation. So for example, obligations under the health and safety laws or financial regulations that might impose a duty on you. Fiduciary duties, they arise where there is a relationship of trust and confidence in another, such as a solicitor-client relationship or a trustee and beneficiary relationship. Now, contractual duties, they are the more common one, and they stem from the terms of a formal agreement between the parties. For example, a contract of engagement. Further, if you are governed by a professional code of conduct, then this may be relevant both in determining whether you have a duty or whether you have breached your duty. So if you are governed by a professional code of conduct, do just make sure that you are familiar with it. Now, once a duty of care has been established, then you will have to be able to prove that there has been a breach of duty. Now, this, as Graham is going to come on to a little bit later, involves assessing whether the professional has met the standard of care expected of them in their field. Now, I won't spoil what Graham's going to say later, so let's move on. So finally, the third element here is causation and loss. So it's not going to be enough to show that there was a duty has been breached. It will also need to be able to show that the breach of the duty has caused the loss which is being claimed. Now, this is where the but-for test comes in. It's something you might have heard of. But essentially, it means would the loss have occurred but for the breach? Now, for an example, a tax advisor fails to file a client's return on time and it results in penalties. Now, if the client can show that the penalties would not have occurred but for the advisor's breach, then causation may be established. However, if the penalties were due to the client withholding key information, the advisor may not be liable because the loss wasn't caused by the breach, it was caused by the client withholding the key information. So each of these elements, duty, breach, causation and loss, must be proven. If any of them is missing, the claim is likely to fail. Now, these are the building blocks, and understanding them is essential if you are going to navigate and understand professional negligence.
So, thank you. So, Bolam, from the Bolam test, as it's called, from the test of Bolam versus Free and Hospital Management Committee, is really a very good example of, I suppose, how a court, how law would operate around professional negligence. Originally, and the sort of, I suppose, the build-up of the case law on this, originally the law really only recognised two professions. I'm not boasting when I say this. One was lawyers and the other was medics. But as things have gone on, and obviously lawyers need to make money, it's been broadened out so that there are other professionals who are now, as it were, targeted. But to begin at the beginning, Bolam also kicks in just in terms of timing, 10 years roughly after the NHS kicks in. So again, doctors are coming, I suppose, a lot more commonplace. It's a lot more of a public thing. But with the Bolam test, the test really, the case determined what the reasonable standard of care was for doctors and other professionals. And if just go on to the next slide. So in short, the case was really around whether the treatment that the doctor gave in Bolam was the correct treatment. There were arguments run at the time that there were other ways that doctors at that time were carrying out the particular method of treatment. And an argument, the case was really run on the basis that in Bolam, the doctor had not met, as it were, what was expected of him, as a professional. And what the case says, as we've set out here, basically the court found for the defendant, but it said a doctor is not guilty of negligence if he's acted in accordance with the practice accepted as proper by a responsible body of medical opinion, skilled in that particular form of treatment, nor is he negligent merely because there is a body of opinion which would adopt a different technique. And hopefully you'll see from that what it's basically saying is, and this is very simplistic, if as a professional you can show that the manner in which you acted when carrying out fulfilling your duties, acting under the contract, is in line with how another professional, or rather putting it slightly wider, another body of opinion within your profession would have acted, you are likely not to be negligent. So just because, as it were, you would do it one way and somebody else would do it another way, there might be, as it were, two schools of thought that would still operate to mean that you weren't negligent. The rub, therefore, would come if you acted, as it were, so far out in what other professionals would do that you don't even fall within the test. And so, as I say, provided the professional acts within a recognised school of thought, she's likely not to be negligent, but it must be within the Bolam test. And the example, which again, so I'm being very macabre today, but which I was always given, as it were, when I was at law school, and which I think sort of broadly holds true today, is in regard to, say, going into hospital to have a leg amputated. And again, sorry about that, I don't mean to offend anybody. But broadly, if you're supposed to have, as it were, we'll call it the right leg, because obviously that won't confuse us with the wrong leg. If you're having your right leg, as it were, chopped, then effectively we are looking at a scenario where if you go into hospital and the doctor cuts off the wrong leg, he takes the left leg, that is pure negligence. It doesn't fall within the Bolam test because it's so wrong that there is no argument in regard to sort of whether there's no argument, there's nothing to discuss. But the question then comes, if the right leg is taken off, but there is still, say, an infection or something goes wrong, whether that, as it were, medical procedure is carried out within the acceptable boundaries of a body of medical thought. So again, if it was done under, as one would expect, in an operating theatre with anaesthetic, with sterilised, equipment, and everybody, as it were, or there's a body of thought, a recognised body of thought that would say that that is the right way to do it and the method of going about it is correct, then the argument would be that there is no negligence because you've operated within a recognised school of thought. But if, for example, and again, I'm being very blunt with this, the operation was carried out in the car park or near the bins, with a saw that was bought from B&Q, that in that scenario, again, there would likely be questions because it would be highly unlikely that that procedure would have been carried out within recognised professional practice. So those 3 points, as it were, is it so, is there no way that you would have a body of thought that would back it? Likely to be pure negligence. If there is a body of thought that would back it, likely to be, as it were, not non-negligent, no negligence. If it's done, but there are questions over how it's done, there is no body of thought. Again, you can still fall within the negligence bracket. So again, that's, I think, the way most lawyers still look at it today, and Bolton is still mentioned in a number of cases, even the ones that are going to come on with the case like later on. So that's Bolton.
Thank you, Graham. Right, so turning now to loss, fortunately not the loss of the leg, usually some other financial loss. There are limits to the loss which can be claimed. So the first loss point is that the loss must fall within the scope of the duty owed. Now, this means that the loss suffered must be one that the professional had a duty to guard against. It's not going to be enough that the harm occurred. It must be the kind of harm that that duty was intended to prevent. So if we look at an example, if a solicitor is advising on a property transaction, their duty may cover their legal risks, but not necessarily market fluctuations. So a drop in a property value due to economic downturn isn't going to fall within the scope of their duty. Now, the second point is the loss must not be pure economic loss unless there is a specific duty for it. So economic loss is a complex beast, and I'm only going to mention it very briefly here. Essentially, it's a financial loss unconnected to physical damage or injury, and it's something which must be claimed in the context of contract cases only. However, generally, the law is cautious about allowing claims for pure economic loss unless there is a recognised duty not to cause it. So again, I think it's helpful in this context to think of some examples. So if an accountant negligently prepares a financial report and that leads to a failed investment, the resulting financial loss may be recoverable, but only if there was a clear duty to prevent that kind of loss in the contract. By contrast, if a builder installs a faulty window that causes no physical damage but reduces the property's resale value, that loss of value may be considered pure economic loss and not recoverable unless there is a duty which specifically covers it. Now, the third point here is that the loss must be a foreseeable consequence of the breach. It must not be too remote. Now, this is about proximity and predictability. So the loss must be natural and a probable result of the breach. Something unexpected or far-fetched isn't going to cut it. So, for example, if a surveyor fails to spot subsidence and the buyer incurs repair costs, then that's foreseeable. But if the buyer later loses a business deal because they were too distracted by the repairs, then that secondary loss of that loss of business deal is going to be considered to be too remote. Now, in summary then, not all losses are going to be recoverable. They must be within the scope of that duty, not pure economic loss unless that duty exists, and they must be foreseeable. Otherwise, the claim is likely to fail on this final hurdle. Now, on the topic of loss in professional negligence cases, the law expects the injured party, leave the slide on. Now, the law expects the injured party to take reasonable steps to minimise their loss. Now, this means that they can't simply sit back and allow the damage to escalate unchecked. They must act sensibly and proactively to reduce the impact of the breach. An example of this is if a financial advisor gives negligent investment advice and the claimant becomes aware of the investment is failing, they're expected to withdraw or restructure the investment wherever possible, not to leave it untouched and then claim for the full loss later. Equally important is the flip side. The claimant must not take unreasonable steps that increase the loss. If their response to the breach is reckless or disproportionate, they may not recover the additional loss caused by their own actions. So if we take this scenario where a solicitor misses a filing deadline, the client responds by launching an expensive and unnecessary legal campaign to recover their reputational damage, then the court may find that the cost of that campaign were avoidable and therefore they're not going to be recoverable. Ultimately, the duty to mitigate is about fairness. The defendant shouldn't be liable for losses that the claimant could have reasonably avoided, nor for losses that the claimant has made worse through their own unreasonable conduct.
Right, so tips to avoid a claim, and I hope that sort of from where we've started to where we are now, themes are sort of starting to come out. But I suppose in my experience, I used to work in London really just doing professional negligence once upon a time in the insurance world. The main thing that I saw really were I suppose, primarily omissions. I would read files, as it were, clients' files, insured's files, and they would start out, as it were, with a to-do list. And on that to-do list, there might be 10 items, and those 10 items would come up regularly, over perhaps a 6-month period. And then all of a sudden, for no reason that was obvious on the file, it might drop to 9 action points, and one had just vanished, and there was often never any explanation. I know this sounds twee, but there was never any explanation as to why that one had fallen off the radar, and it would always really be that one that was the cause of the negligence. So often, I suppose these things, the point I make is these things are considered, are reviewed, are considered at the beginning of the file, and when you take on the client. But then, as it were, they just get lost in the ether, or the project takes a turn, so there's a more focus on this than on that, and so it sort of gets lost. And so I suppose that is the one sort of overriding theme that always I see with negligence. Other more, I suppose, trendy things that we're seeing: breach of confidentiality now with data protection rules, emails. We saw one in the press, didn't we, with Kennedy's the other day, where they circulated an email to a list of survivors, and it was a confidential list. That would obviously be potentially a big claim, I think. But data protection confidentiality does seem to be, as it were, very much a zeitgeist point. Again, things that you wouldn't really expect to see in this day and age, when we've got electronic documentation and so forth, but just lots of documents. Again, as somebody who worked in London and did a lot of these claims, sometimes the deeds will just go missing to properties and so forth. Now, again, with the way modern life is, that's less relevant, but we do still seem to see a lot of claims or issues around documents being lost. And I suppose the last one, which is the more obvious one, is actions, going back to what we discussed before, really just errors in things like drawings, plans, setting out groundwork, structural, tolerances, etc. I suppose wrong actions, something that put us there, but just things that sort of go down and almost compound themselves. That a wrong turn is taken to begin with, and then rather than almost identify that early, it keeps going and then gets to the point where it's almost too late to then be backtracked on. So again, just a broad overview, what can you do? What tips, as it were, can be done to avoid? Well, I suppose the starting point, as we've talked about, is really the contract that you have with your clients. And if you're obviously you are a client, then I suppose check the contract that you have with your professional. I think it's important that the letter of engagement, the terms of business, sort of cover what one would expect to see in contracts. So one big issue, for example, in construction is obviously scope. If you're not, if you're only being, employed to perhaps design but not build, and a lot of this is already covered, for example, in the JCT type of contract that you would use. But again, we see in building time and time again that often contracts of what you would call sort of a recognised nature and not entered into. It's much more ad hoc, or the worker, the professional will have their own terms. I think it's important that the engagement letters really cover one of the basics. Do you want to limit liability? What is the scope of the work that you're doing? What actually are you doing? In our engagement letters, we talk about sort of, you have come to see us, your objective is this. Fulfilling your objective will be these steps. This is what we will charge. Charging obviously is another aspect. Complaints, procedures, and so on. It's important really that you think about the type of work that you're going to do, and that robust terms are put in place. I suppose coming on from there again and touching again on Ellie's talking about professional regulations, we as solicitors have no end of policies internally that we must abide by. The SRA states that we must act in a particular way, and so our firm has plenty of policies. We have staff, as it were, training, and we also have supervision, whereby the policies are, writ large, so everybody in the organisation knows what to do if certain situations come up. And we have ongoing training, as it were, generally to make sure everybody is up to speed with what's going on, latest developments, etc. And by that, I don't necessarily mean go back to Bolton, as it were, the latest developments in how to practice. That obviously is key. But I think also regulatory elements are becoming more and more relevant now. The standard is being set by the regulatory body in a way, often or more than perhaps the developments in the law and the profession. What the SRA is seeing perhaps is different to necessarily how the courts are taking it. So it is a sort of a patchwork quilt, and we've got to make sure that we're up on all of these things. Risk assessments. Now, again, we risk assess every file that we take on at a very early stage. This is partly because our regulations mean that we are very heavily money laundering sort of centric. So we have to identify our client, look at what our client does, make sure that they're not sort of based abroad, make sure that there can be no allegation that money will be moving in and out. And as a result of that, I suppose that then really is sort of a framework for many solicitors that focuses on not just the client, but also then the transaction or the work that's involved, whether it's within the scope of what you actually can carry out. As somebody who deals with professional negligence, I have to say, thank God I've not been in this situation, but I have seen lawyers and other professionals bite off more than they can chew. And so I remember again being told by one of my mentors back in the day, I make more money, or rather I suppose the better way to put it would be to save more money by actually separating the wheat from the chaff and working out what is likely to be good and what is likely to be bad. Client care, again, another key one. What we often see is that things escalate very quickly, just simply because the professional isn't actually communicating very well with their client. So you'll see as you read through the file, there's a lot of what's happening, where are we, what's happening, and there's silence, or the answer is kind of very limited. And so again, sometimes I think very key point again, perhaps, but by having more jaw, we can avoid more. So I would say good client care is obviously key. Sort of based around that, I think sometimes even if the communication is not that good, a good complaints process can actually salvage the situation. Most, I think, professionals will probably have one of those as a result of their own regulatory body. I know, for example, solicitors have to have a complaints procedure, and that has to be set out in their letter of engagement. But if I suppose you're looking to claim against a professional, or if you're in an area that is unregulated or more unregulated, operating and using the complaints procedure process is a starting point. I think both ways, and it could salvage time and a lot of court cost. And just simple things, which again, I think lawyers have learned their lessons on now, and we'll have these, a diary system to make sure deadlines are not missed, and really a good document management system, as I've said, based on the lost document situation that I've outlined. So that is tips to avoid.
Thank you, Graham. So Now, if we turn to how professionals can limit their liability, or at least limit their loss in the event of a negligence claim. So the first point I've put on the board is insurance. Now, professional indemnity insurance is the first line of defence. It provides financial protection against claims arising from negligence acts, errors, or omissions. Insurance will need to be in place prior to the material time if it's going to be relied upon. So it is a proactive step rather than a reactive one. And if you do have professional indemnity insurance in place, then you must be careful not to do anything which is going to void your policy. So make sure that you're familiar with the terms. Now, it is important to note that insurance doesn't eliminate liability. It can absorb the financial loss or impact that a claim may have, and it will ensure continuity of service. So it will allow you to kind of continue business as usual while this is going on in the background. Now, exclusion clauses, these have kind of been mentioned already today, but professionals can often include exclusion or limitation clauses in their contracts to restrict liability of certain types of loss. So, for example, an architect might exclude liability for delays caused by third-party contractors or cap damages at a value of their fee. However, these clauses must be reasonable under the Unfair Contract Terms Act 1977. The courts will not enforce exclusions that are unfair or ambiguous, especially in consumer contracts, so contracts with individuals. The law will try to protect individuals from an imbalance of power when contracting with companies. So, you can't just go out and say, well, we're not liable for anything. You really must make sure that that is specific and reasonable. In a similar vein to exclusion contracts, it's always worth considering liability for negligent misstatement. So if a client asks you for bespoke tailored advice, the advice that you give may be correct for that specific scenario. But if that advice ends up going around the houses and is used in an incorrect scenario, you may want to avoid being held liable for any fallout that it causes. It is therefore always worth caveating your advice and making it clear that you're advising on this specific scenario only, just to try and limit any liability for negligent misstatement arising in the future. And the third point that I've got on the board is limitation. Now, liability may be limited by statutory time limits. So under the Limitation Act 1980, most negligent claims must be brought within 6 years of the breach. Now, if brought outside of that limitation period, then you will be able to claim the defence of limitation. Now, this 6-year time frame isn't a hard and fast rule. There are some exceptions and nuances involved with it. So, for example, around when that time period starts. So, do just seek advice if you're not sure. You should keep clear records and monitor when potential liability may expire. And if a historic claim does present itself and you're not sure if it's within the limitation period or not, it should be investigated and advice should be sought. Right, so the next step is how to handle a claim. Now, if a complaint presents itself, typically the first thing that you turn to is your internal complaints procedure. And this is something that Graham's gone into detail on. But it's the first step, and it's also often quite informal and will hopefully be successful in appeasing any concerns. Resolving issues at this stage can prevent the escalation and preserve that professional relationship. So if it is someone that you contract with on a frequent basis, then it's really best to kind of nip that in the bud early so that you can both move forward. It also helps to demonstrate good faith and accountability. So many regulatory bodies do require professionals to have a clear and accessible process for addressing client concerns. So if you don't have one, or you think that your procedure may need to be reviewed, then do just have a look at it, because it is important and it can save you some stress in the long term. Now, the second step to insurers. Now, if the complaint suggests a potential claim, then the professional should immediately notify their insurer. For an example, if an architect is facing allegations of design flaws, they should alert their insurer before they even engage with the claimant directly to ensure that all steps are covered under that policy. Most professional indemnity insurance policies will include strict notification requirements. So a failure to report that claim promptly may actually jeopardise your coverage. So yeah, it's always better to alert early rather than later. The third point is the pre-action protocol for professional negligence. So if the matter progresses beyond the complaints policy and insurers, etc., become involved, then this is when the pre-action protocol under the civil procedure rules comes into play. It sets out a structured process for both parties to follow before the formal litigation is commenced. Now, I've set out a brief overview of the pre-action protocol for professional negligence on this slide. As you will see, it is a structured and staged approach, and it's designed to encourage an early and effective stream of communication in the hope that resolution is reached without the need to go to court. So as you'll see, the first stage is preliminary notice, where the claimant informs the professional of a possible claim. So this is going to be very brief and basic, and it's at this point, if you receive a preliminary notice, then you should alert and make your insurers aware. Now, you will then receive a letter of claim, if it's something that they decide to follow through with. And this is going to be more detailed, and it's going to sort of outline all the facts and the grievance in full, and it should include supporting documents. Now, that any letter of claim received should be acknowledged within 21 days, and you'll have 3 months to fully investigate the claim and formulate a response. So your response letter should either admit, deny, or partially admit liability. Now, if you're admitting liability, then it may be some form of a settlement offer that you make. If you're denying, then settlement is maybe something that you're not willing to consider at this stage. However, throughout, parties are encouraged to use ADR, which is alternative dispute resolution methods. So this may include mediation or other forms of negotiation. If the matter does remain unresolved, the court proceedings can be initiated, but a failure to comply with the protocol may have cost implications in later down the line. So this slide is a very brief overview. If you are interested and wanted to have a read through, you can access the protocol in full online just by searching the pre-action protocol for professional negligence. Moving on now to case law updates.
Right, thank you. So as we've said, Voted Bolden from the 1950s, the sort of framework for professional negligence is pretty well set, but we thought we would try and sort of give 3 cases in this instance that have come up recently that are sort of interest, and also I think highlight some of the points that we've touched on. So the first one, again, the surveyors amongst you will probably be familiar with some of the details around this type of claim, not because you've experienced it, just, I mean, it's part of your training, as it were, but broadly Bratt versus Jones. So in Bratt versus Jones, there was an option agreement to purchase development land, and then under the terms of the option, there was, as it were, a sort of evaluation that had to be carried out. There was a disagreement, as it were, as to the value. The seller's valuer valued the land at 8 million. The buyer's value valued it at 1.8 million. So going back to sort of methods of trying to reach some form of middle ground, Mr. Jones, the defendant in this case, was jointly instructed by the buyer and the seller to determine the value, and he came back with a value of 4.075 million. Now, the seller wasn't happy with that and then brought a claim effectively against Mr. Jones, saying that his valuation was a significant undervaluation, and he looked to sue for the, as it were, difference. The court looked at this and decided that to be negligent, it needed to be proven that Mr. Jones had failed the Bolden test, which we've gone through, and that the valuation was outside the permitted margin of error. And there's a very famous case called Merivale Moore, which talks about surveyors being given a margin of error in relation to their valuations. And broadly, the court sort of looked at this and formed its own view based on the evidence before it that the actual value of the land was 4.7 million. And so they, again, in that situation, again, surveyors amongst you will know that there is this sort of ongoing margin of error that is around the 15% mark. They determined in this case that the acceptable margin of error was 15%. And so therefore the defendant's valuation of 4.075 was within the 15%, 50% of the court's own valuation of 4.7, and was namely 14.15% less. And so Mr. Jones was not found, was found as it were not liable, not found liable. So in short, again, that's an illustration really in a way of how the Poland test would operate. The standard, as it were, for the margin of error in that scenario was assessed as being 15%, and he fell within it. So again, just a recent case confirming, as it were, the 15% as the margin, and sort of touching on Poland.
Okay, so another recent case that we have is MJS Project Limited and RPS Consulting Services. So MJS Projects was the main contractor for a container yard project near Felixstowe. Now, RPS Consulting Services was engaged to provide design services. After completion of the project, there was some damage which appeared around the slot drains in the yard. Now, MJS, the main contractor, alleged that the damage had been caused by the designer's negligent design, and they brought a claim for breach of contract and professional negligence. Now, RPS claimed it was not the design, but it was the workmanship which was at fault. Now, the key legal issues which were considered in this case by the court were, was the damage caused by the defective design or the poor workmanship? Did RPS breach its duty of care as a design professional? And was the claimant's expert evidence reliable and sufficient to prove causation? Now, the court found that the case turned heavily on the expert evidence. It was for the claimant's expert, essentially, to prove that it was the design which was at fault. However, the judge found that the claimant's expert was unreliable. The judge noted failures in particular in relation to the methodology, the transparency, and his adherence to the CPR Part 35 duties. Now, the defendant's expert was therefore preferred, and the court concluded that the damage was likely to be due to the construction errors, not the design flaws. Now, the judge applied the Boland test and confirmed that RPS's design met the standard expected of a reasonably competent professional in their field. So even if there was a bit of a flaw, it was within the recognised body of medical thought and, sorry, not medical thought, construction, should we say, and the claim was dismissed. The court found no breach of duty or causative negligence on the designer's part. Now, the significance of this case was that it reinforces the importance of expert credibility and proper adherence to the procedural rules. If the claimant's expert had been better prepared or perhaps more experienced, then it may have been a completely different result. This case also highlights the distinction between design liability and construction workmanship, and how it can be difficult to determine between the two and who is at fault. So this is why both sectors need to keep clear and accurate records and a detailed thought process for their decisions, as you just never know when you might need to turn on them. So yeah, that's that one.
Right, the last case you please here, Vitso Limited versus Wall Thistleton Architects Limited, one for the architects amongst you. Now again, this was a scenario where the claims against the architect for rotting and decay of roof panels that had become wet over the Christmas period of 2016. The rotting had led to water ingress into the property and more damages. Now, the architect had been instructed to design Vitso's new headquarters, but Vitso had also instructed the construction manager, who had a specific duty to review the designs and advise on their feasibility and suitability. So, going back to what I was saying before about setting out or trying to set out the scope of your, as it were, work, scope of your job, I think that's sort of, that's a good thing, as we've said, to set out in your engagement letter. Here, the Technology Construction Court dismissed the claim, and it found that under the construction management procurement structure, the defendant's role was limited to design. So again, the procurement structure and the terms of that procurement structure would actually save the architect, as it were. As I say, a good letter of engagement might have done the same as well, but the defendant's role was limited to design and providing, as a result of that, drawings and specifications. It was not to protect the works, as it were. The architect was not, in this case, as it were, responsible for what was happening on the ground. Of course, that responsibility lay with the construction manager and trade contractors. Again, I think in this situation, the architect was, as it were, I say lucky, that's not fair, but it was good that there were other professionals, as it were, who had been employed to do other duties, because it almost then separated and isolated the duties that the architect was supposed to do, as it were, despite the architect. So again, court found that there were other professionals to do that job, and that the architect didn't owe a duty of care for moisture protection, sequencing and site conditions. That was down to the construction manager. So again, I think good contract terms can be used to assist with that. But again, that's just a very recent one that's been reported. So in conclusion, as I said at the beginning, really, hopefully we have touched on the basics and given you a flavour of how a court would look at professional negligence. We've touched on what we see as the common pitfalls, primarily omissions. We've talked about, as best we can, how to avoid claims, and I'm sure most of you are doing much of this already. We've also really touched around the starting point of what to do if a claim presents itself. So that really is our talk. I appreciate with any professional negligence scenario, questions may be something which you might not want to air in public. I know that none have come up as with talks. Normally, if there are any, we get them sort of throughout the talk. So if anything comes up, or you've got one now, by all means fire it in and type it in. But as it's silent, I'm working on the basis that there isn't one. If any of you do have any specific questions or concerns, or there's an aspect of the talk that you would like more on, or that you have questions around in terms of what you're seeing, please get in touch with either of us, and our contact details are there. The slides will be sent out to you. As I always say at our live events, we are a learning organisation. We do listen to our delegates, our attendees. So please, if there is a talk that you're interested in and that you'd like us to specifically try and deal with, we will endeavour to incorporate that into litigation lessons going forward. I appreciate sometimes they can be a little bit too specific, but as I say, we will try and cover them on a broader basis if possible, but you have our emails if not. So thank you all for attending.
Thank you very much.
Company, and we'll see you at the next one, and we look forward to hearing from you with any feedback that you have. Thanks very much.
Thank you. Bye.